Are the Yoders here?
I get.
Somebody filed something. Did you get a copy of this, Lance?
I did. Somebody handed it to me, but it was not the Yoders that handed it
Oh,
to me.
okay. Well, I just got it a minute ago, so. All right, well, it is the appointed time. It's 2:02. Let me call these cases. Get them set out here. There are matters in two separate cases before the court. Oh, yes, thank you. Everybody may need to scooch down. There are two separate matters before the court here today. And there are several things that we're going to need to address. The title of the cases, for starters, is Colon Township versus Joanne Yoder, which is 25533CZ, and Colon Township versus Alfred Yoder, which is 25533CZ. There is a preceding case, Colon Township versus Alfred Yoder and Joanne Yoder, which is in file 252040CZ. In 25040CZ, there is a permanent injunction in effect that was ordered by Judge Stutzman earlier this summer in July. And the defendants were compelled to appear at a show cause hearing, and they failed to appear. And Judge Stutzman issued bench warrants for their arrest. The way I read the petition, it is for civil contempt, set bond at $1,000 cash in each case. I believe last Friday, I found out about this on Monday. The defendants apparently presented themselves at the jail on August 22nd, posted $1,000 cash bond in each case, and were given a notice to appear for today for the show cause contempt in file 25040CZ. Plaintiff Colon Township has filed a brief in support of a motion for preliminary injunction, actually requesting a permanent injunction, and file 25533CZ. These are two separate parcels of property. 25040CZ is 30158 Marsh Road. I believe the property known as Mama's House, which has been in operation for some time. The second case, 25533C, CZ has the same addresses, but it is a different parcel of property very near the other property on Marsh Road.
It actually has a separate address.
Adjacent to,
30246.
what is the number?
30246 Marsh Road is the 533 CZ case.
All right.
Now the Yoders live at 30158.
All right.
That's their address.
This is adjacent. All right. Now preceding all of this, all right, we'll get a little background. This matter has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge, and this matter was filed for hearing in the circuit court. Judge Stutzman made some rulings and issued these two bench warrants. Sometime after the bench warrants were issued, I was assigned by the Supreme Court to hear this matter. Judge Stutzman has disqualified himself for reasons that are known to him. And he actually called me while I was on vacation and asked me whether I would take this case. And I said, yes, I would. So Mr. Thornton has filed a motion to, I guess, reassign me or disqualify me under the theory that the matter should have been assigned to a circuit court judge. And so we have to deal with that before we deal with anything else. Once the order of disqualification was entered, Judge Stutzman signed it, Judge Pattison signed it. I don't remember whether Judge Kane did. I had already agreed that I would take it. Mr. Thornton, you're aware of this. St. Joseph County is part of a concurrent jurisdiction plan. That was entered on January 16th of 2013, and I'll provide you with a copy of that. And the concurrent jurisdiction plan indicates that the benches will share obligations. There is a statute 600.8304 regarding jurisdiction. A district court, in a district court district, which the district court is affected by a plan of concurrent jurisdiction adopted under Chapter 4, the district court has concurrent jurisdiction with the circuit court or the probate court or both, as provided in the plan of concurrent jurisdiction. So just before you folks all came in here, I did a personal protection order matter, and I've done dozens, maybe hundreds of them. Those are circuit court matters, and we are all cross-assigned under our concurrent jurisdiction plan, and all 4 judges actually do personal protection orders. And I do my share, and I had one just a few minutes ago. On a number of occasions, I have covered circuit court matters in criminal disqualifications. I'm the primary backup for Judge Stutzman if he has a case in which he has to disqualify himself in a criminal case. So those are felonies. I've handled a number of those. I'm also his primary backup in zoning cases. And he's had several occasions over the years where he's had to disqualify himself in zoning matters. He disqualified himself in Lockport Township because he lived very near where the property at issue was. Recently disqualified himself. He moved to Fabius Township, and they had a complicated matter regarding solar farm, and he was disqualified, and I was assigned by the Supreme Court and our chief judge to hear the matter. So Mr. Thornton has cited some of the case regarding that, but Mr. Thornton, I do not believe it would require that I not be eligible to handle this case. I'll ask you if you have any other comment, but it's my intention to deny your order to reassign a judge. What would happen is it would then go to the next judge, who would be Judge Pattison or Judge Kane, who would know even less about this than I do. But I don't feel like I know less. As you know, we do lots of zoning cases of all shapes and sizes. And so it's my intention to deny your motion, but is there anything else you'd like to place on the record?
I appreciate the court providing me with a copy of the concurrent jurisdiction plan.
Do you have one yet?
I do.
Okay, yes, I do. So I think I said that.
So not sure I agree with the whole concept, but I understand the law. I've read it and read the concurrent jurisdiction plan. I understand it, and understand that it provides that this can happen. Before Your Honor actually rules, though, I would just like to inquire, because it does appear that Judge Stutzman said he had a conflict. Judge Pattison has indicated he has a conflict. had some knowledge or had spoken with the Yoders or their friends or both. On behalf of the township, I would just ask if Your Honor feels like there's anything that he knows or has been introduced to that would cause a conflict for Your Honor in this matter.
Well, that's a fair question. In the last case, I represented that I was going to dinner at Farron Hall shortly after our hearing. That was an issue that I raised myself. The answer is no. I know very little about this. I was at a county commission meeting when a number of people got up and spoke at the commission meeting about this issue. And that was the first I even heard of it. I don't know any of the parties. I know very little about it. I have not discussed it with Judge Stutzman, other than when he called me and asked me whether I would accept the assignment. So no, I don't know the facility. I've never had a case involving Mama's house to my knowledge. I don't know Joanne Yoder. I don't know Alfred Yoder. Lord knows I would be more than happy to foist this off on another judge down the line, but I don't feel I have justification to disqualify myself. So for the record, I don't know the parties, know very little about the case. In fact, I was totally uninformed when the parties were at the commission meeting speaking about it. I asked my administrator, she had some knowledge of it. But so the answer is no.
And I accept that. And so I'll just let the court make its ruling on my motions.
All right, I will do a formal order denying your motion in each case. So that's our first order of business. Our second order of business is to deal with the bench warrants. Because I didn't know anything about this case, I had to familiarize myself with the file. And so I spent some time going through both files, 25040CZ and 25533CZ. Things are mostly done in the 25040 case. Judge Stutzman entered the judgment of permanent injunction on, I can't read it, March 13th, I think it was. So that case has been decided. However, there was a show cause and then there was another show cause. And he issued 2 bench warrants. And then I was confused because the bench warrants were issued by Judge Stutzman and the clerk on, I believe it was July 7th. And the Yoders were personally served by Sergeant Morse from the Sheriff's Department later in July. At the time they were served of the notice for this hearing, they were open bench warrants for their arrest. I had a question of why weren't they arrested when they were served with the warrants? And I don't know that I got an answer to that. I don't think they wish to have a confrontation. I think there'd been some discussion about having them present themselves in the warrant, but a sheriff's deputy had personal contact with the defendants while the bench warrant was in effect, but it was not served.
My understanding is Bruce Morris doesn't conduct arrests anymore.
He does not, but he would. He doesn't. I don't want to. He does a wonderful job for us, as yes, you know. He handles our service, and he makes my life much easier by being so competent and professional. But at any rate, he is still deputized by the Sheriff's Department. Anyway, so eventually the Yoders presented themselves at the jail on Friday the 22nd. We're given notice to appear today, and they're not here today. They posted $1,000 cash bond, each of them, and filed 25040. And there's a notice from the sheriff to appear today at this time and date, which is good because we were already scheduled to be here today at this time and date.
I wasn't aware that anything had been set for today for that particular issue, but
yes, let me see. I think I copied the notices. They were given notice by I can't read the deputy's name. I guess I saw the original copy for August 29th at 1400 hours, failed to appear on the show cause. So they aren't here now. A number of other people are here. So I can't arraign them on their bench warrants because they aren't here. Someone was here earlier this afternoon, and these were signed and date stamped August 29th. I received what I is entitled response and filed 25040 and 25533CZ. So the allegation is that the defendants were in civil contempt for failing to appear for an order to show cause. And now they failed to appear pursuant to a posted bond for an arraignment on the show cause. Mr. Thornton, what's your thought in that regard?
My thought first with the responses that have been filed today, as the court has pointed out in 25-040CZ, there really isn't anything to respond to in that. So I don't know what the court wants to do with that. With the response today attempted to be filed in 25-533CZ, the
Well,
Yoders
let's stick to 40 for a minute because that's where the bench warrants are.
okay.
I'm unhappy that they're not here. I never met them. I don't know them. I don't have any prejudgment about it. Judge Stutzman issued those bench warrants. There was criminal or civil contempt. My inclination is to issue a bench warrant for criminal contempt for failing to appear pursuant to a posted bond and set bond at none. No bond until I see them. They will appear at the jail or be arrested by the sheriff and be held in custody until such time as I can conduct an arraignment. I don't like somebody poking me in the eye with a sharp stick. Judge Stutzman ordered the bench warrants. They did appear and present themselves. They posted $1,000 of cash in each case. Civil contempt is punishable by up to $7,500 in fines, but not a criminal punishment. Now they failed to appear pursuant to this. Now this is a civil contempt in a zoning case. The Criminal Justice Reform Act changed the rules a little bit as to bench warrants in criminal cases. As a rule, we are to give 48 hours of grace before the bench warrant issues in a criminal contempt case. Fail to appear on a bond. And so my inclination, Mr. Thornton, is to issue 2 new bench warrants with no bond until they're seen by a judge, namely me. And give 48 hours. In fact, I would start the 48 hours on Monday. So they'd have until 5 o'clock on, well, Monday's a holiday. I would grant them until 5 o'clock Wednesday, September 3rd to appear.
And I'm fine with that, Your Honor. In that case, as the court's pointed out, we do have a permanent injunction. The birthing center is not supposed to be in operation, and it's my understanding it is still being operated.
We haven't taken any testimony regarding that, but that would violate the permanent injunction and subject them to further contempt if it is still being operated. Anyway, I'm going to issue a bench warrant for Alfred E. Yoder for failing to appear pursuant to a posted bond in a contempt matter. I'm going to set the bond at no bond until such time as he sees the judge. He has until Wednesday, September 3rd to present himself at the court. I would order the exact same matter and Joanne Ann Yoder. I find she's in contempt for failing to appear at this hearing. It's not accidental contempt, it's willful contempt. They don't recognize the jurisdiction of the court. We have a fundamental disagreement on that subject. But if they don't appear this time, they're going to sit in jail until such time as I can see them. So one for Alfred E. Yoder, one for Joanne Yoder. All right, so that finishes 40 CZ, 2540 CZ. That's the case that's done with a permanent injunction. That's on Mama's house. That's the bench warrants were in that case. The other case that it needs to be addressed today, which was set for hearing, is 25533 CZ. That is the other property where something was being constructed, I believe, to supplant or replace the facility that was used for Mama's house. The lawsuit was filed on July 22nd of 2025. The defendants filed no response. We'll talk about today's response in a minute. And the clerk sent out a notice of entry of default on August 22nd. They waited 31 days rather than 21 days, sent out a notice of default. So the matter was set for hearing today. They did not file a response in a timely manner and would be subject to the entry of a default, granting the relief requested by the township. I received today in that case something entitled response. I read it. I'll accept it for filing. It doesn't meet the standard of a legal answer to a civil complaint. It's got some archaic language. It's got a fingerprint.
May I speak on that?
Yes.
Being in default, it's my understanding under the court rules that an answer cannot be filed and accepted by the court until the Yoders would file a motion and show a meritorious defense through affidavits or testimony.
Well, what we're going to do, I'm going to grant your default. Now that we need a default judgment. The entry of the default is in there. What we will need to do is.
After that guy. Was that filed in my office?
It was stamped by Gina Evers.
I don't know if it was filed.
And it doesn't. I wanted to make sure that it wasn't, it's titled a response, so my clerks would not have put it in as anything other than a response. So I would not have used that as an answer.
In district court, we're much more flexible. We take handwritten answers, as you know, in civil stuff and grant the people a day in court. Well, this, whatever it is not filed in a timely manner. So we have a notice of entry of default signed by the clerk on August 22nd. What I need for you to do is move to enter the judgment of default as to each defendant. Your pleadings in that case. Now, the motion for today is for entry of a preliminary injunction. And you did a good job in your brief of setting out the standard for preliminary injunction and what it is. And it's not to be granted lightly, but it's based on the likelihood that the plaintiff will prevail in the ultimate hearing. In your actual motion, that's filed with the court, the relief request, that on page 9, you request permanently enjoining the defendants, agents, servants, assigned successors in interest, or those active in concert or participation with them from using the subject property as a birthing center. This is the adjoining property. So the complaint requests a permanent injunction. They have not responded to that in a timely manner.
I can address this, Your Honor.
Yes.
What I'm going to request today is that pursuant to Court Rule 2.111 E1, the detailed allegations in the complaint, and they are detailed, are now admitted by the defendants due to the default. And the defendants cannot proceed under with the action until the defaults are set aside under Court Rule 2.603A3.
And I agree with that.
And
so what we need to do is your pleadings stand as accepted because there's been no answer, which
so
would, and your pleadings include your signature as attorney for the township. Once we enter the judgment, and you're asking for the permanent injunction?
Well, I was asking today for the preliminary injunction to be entered based on the fact that they're not here to defend, they're in default, and all those, the allegations in the complaint and the supporting documents are at this point admitted by the defendants. What I intend to do then is, let's see, provide under 2.603B1 of the default court rule. I may not be required to do so, but on the just being overly cautious, I will prepare a permanent, a default judgment with permanent injunction, which I have not done yet, but will soon. And I would submit that, send notice to the Yoders, and then set that for hearing and have the court enter it at that hearing.
All right, so what you're asking me to do by default today is enter the preliminary injunction.
That's correct.
All right, I will so order as requested.
And Your Honor should have a proposed preliminary injunction order.
I have the brief and I have the judgment. Let me see if I have the order in here. Do you have a copy?
I do.
By default, the court finds that the defendants failed to file a response in a timely manner to the lawsuit, which was within 21 days. They've also failed to appear at this hearing which also subjects them to default. This is the 29th day of August. This preliminary injunction order states the court makes the following findings. I'm gonna have to change the name, but Colon Township is likely to succeed on the merits of its claim against Alfred E. Yoder and Joanne Yoder with regard to the alleged violations of Michigan's construction code as cited. Defendants are the owners of the following described real property, and that is the subject of this case, and the property is described by a legal description in the order. It's also known by a common address of 30246 Marsh Road, Colon. A building being constructed on subject property without building permits and inspections by qualified building inspectors represents a dangerous situation that could easily result in irreparable harm to persons using or visiting the building, including emergency personnel. The court does lots of these. Routinely, we have zoning violations where people are building things without a permit, garden sheds, additions to their house, garages, which are in the right of way of the road. That's routine zoning matters we do in the district court. I'll continue to quote from the proposed order. The plaintiff has no adequate remedy at law. The risk of harm that would exist if the preliminary injunction were not granted outweighs the inconvenience to the defendants caused by granting the injunction. The public interest is furthered and not harmed by the granting of the preliminary injunction. The applicable law cited in plaintiff's brief and support motion for a preliminary injunction authorizes injunctive relief under the circumstances. And as I mentioned, Mr. Thornton filed a brief which was well cited with the facts and the law. It is hereby ordered that the above finding facts are hereby, the above findings of fact are hereby incorporated and made a part of this order. Plaintiff's motion for a preliminary injunction is granted. The defendants and their officers, agents, service employees, attorneys, assigns, successors in interest, or anyone in active concert or participation with the defendant are enjoined from performing any further work on the interior or exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by plaintiff's building code officials, and the stop work orders that have been issued and posted are rescinded by the plaintiff's building code officials. And occupying the building on the subject property or allowing anyone else to occupy the building unless written authorization to do so is obtained from the plaintiff's building code officials. Colon Township shall cause a certified copy of this order to be posted on the front door of the building of the subject property within 10 days of the entry of this order, and no one shall remove the posted copy of this order from the front door unless and until the removal is authorized by the plaintiff building code officials. This order will remain in full force and effect until this court specifically orders otherwise. This property is posted, and there's a copy of it in here with a prominent no trespassing sign. And arguably posting this on the front door of the property. So you may post this on the trespassing sign,
Right.
where you won't have to enter onto their property over their objection. There's a trespassing sign of some elaborate detail in front of the property.
Or would the court entertain adding to my order that we be allowed, permitted to go on to post it on the front door with a
Well,
peace
it already
officer.
says that, but I don't want a confrontation.
Well, I would request a peace officer from
All
the,
right, well, then I'll leave it as you drafted it. Signed effective August 29, 2025. This order is entered by default. Failure to answer in a timely manner and fail to appear for the hearing. And Mr. Thornton started to speak to this. When a default is entered, a plaintiff can move to have the default set aside. I believe it's within 21 days of the entry of the default. And in order to do that, you have to show good cause for failing to appear or answer, and you have to show an affidavit of meritorious defense. And this comes up all the time in my court. Lay people are being sued by an insurance company or a hospital or an auto lender, and they get defaulted and they don't understand what's going on, and they file an answer in a handwritten letter, but it doesn't rise to the level of the statute to set aside a default. You need just cause for failing to appear at the hearing, and I don't know what that is, because they aren't here, and as I said, I'm not very happy about that. And secondly, they have to show an affidavit of meritorious defense. The document entitled response, I make no finding on whether it is an answer, appropriate answer. Whatever it isn't filed in a timely manner. And secondly, they aren't here to address it. You don't swing by the courthouse 5 minutes before the hearing, drop off a vague pleading and cover your bases. That's not how it works. They were willing to present themselves on the warrants and post the bond. So I'm disappointed that they aren't here. I had hoped to engage in some sort of dialogue. In true point of fact, they need a lawyer. They need a lawyer who's licensed in the state of Michigan. They're going to end up in jail. There may be legitimate defenses to this. There may be issues that could be explored by competent counsel. They have their own reasons for choosing not to retain counsel and be represented by themselves. But in the humble opinion of this court, they could benefit from competent legal advice because they're going to end up in jail. They're going to end up in jail unless they appear by next Wednesday at 5 o'clock, because they're going to sit in jail until I get a chance to see them. They were ordered to appear by Judge Stutzman. They failed to appear twice. He issued a warrant for their arrest. They were given a notice to appear today, and they gave me the same discourtesy they gave to Judge Stutzman in failing to appear. So I can't even talk to them. So let's recap. I've denied the township's motion to disqualify myself because there is a concurrent jurisdiction plan in place. I handle these matters in my own court routinely. This is not outside the province of cases that I regularly do. So I'm going to do a written order denying that in each of the two cases. Secondly, I intended to arraign the defendants on the bench warrants in 25040CZ, but they failed to appear. So I issued new bench warrants with no bond. The defendants are allowed 48 hours, in this case, a little more than that, until next Wednesday at 5 o'clock to present themselves either at the jail or at the court. The bond is none. Third, I've granted plaintiff's motion to request a preliminary injunction and file 25533CZ. Mr. Thornton intends to file a further notice asking for a permanent injunction, and again, giving them an opportunity to respond. But until further order of the court, the preliminary injunction is in place to prohibit any further construction or occupation of the second building. Mr. Thornton, is there anything else we need to do here?
No, I will see the court, Your Honor Secretary, about getting a date for the next hearing for that proposed default judgment.
All right, very good. It's easier than it was with my schedule, vacation schedule, the judicial conference. We're good now till deer season when Judge Pattison is gone much in November, but we're here for the duration, so it should be easier to find a place to put this than what we had for today.
Okay.
All right, this is a public courtroom, and I appreciate that. This matter is also being live streamed. You can watch it on YouTube. It's important to have a public courtroom that people can come into and sit and see what happened. We just saw what happened. You may not agree with it, but it wasn't done in secret. So we'll see how we proceed further. Thank you all for being here today and your decorum.
Thank you, Your Honor.
I've signed an order. The clerk will prepare it, and I'll do my other two orders. Denying your motion to disqualify.
Yeah, I'll
Prepare the bench warrants.
What's that?
You're gonna prepare the bench warrants.
Yes, we should make that. I'd ask you to prepare the bench warrants as the last.
Okay. Okay, I will do that.
And so, just so that I'm clear, so.
Just a minute, let me go off the live stream and the record. All right, we're completed this matter. Thank you.
Gotcha.
Good morning. Are you Ryan?
Yes, I am.
Welcome to Centerville.
Thanks, sir.
I knew you were coming today, but I apologize. We didn't have a very dense day. I'll catch up with you after we go off the live stream. We do have a special visitor here with us, Ryan from Oklahoma. He emailed earlier this summer to make sure we'd have something going on. And if I lived in Oklahoma, I would like to be in Michigan right now because it's pretty good. I don't know what it's like out there, but right now here, it's pretty good. All right, this is the time and date for the sentencing in the matter of People versus James Jonathan Harvey. I've been spending a lot of time with Mr. Harvey lately in the context of some of his other matters. He was charged with operating while intoxicated on May 15th when he actually drove to the courthouse while intoxicated. He's here with his lawyer, Mr. Luke Nossinger. By some, I'm not sure exactly what happened, but Mr. Nossinger took over for Mr. John Bush, who was his previous counsel, and Luke is very familiar with our Sobriety Court treatment program. Also present is Assistant Prosecuting Attorney Angelique Canfield and Matt Huff from the Probation Department. Mr. Huff has prepared a pre-sentence screening report with a lot of information in it. Just as of this morning, I did get Mr. Harvey's assessment report from Pivotal, and that was enlightening also. Good morning, Mr. Nossinger.
Good morning, Your Honor.
What would you like me to know here?
Just a couple of things, Judge. It was a happy coincidence that took over the case here for Mr. Harvey. I'm not only familiar, as the court said, with Sobriety Court, but I'm also familiar with Mr. Harvey. And the alcohol is the issue here, Judge. there's not really much to add here. Mr. Harvey wants help. We'll get that help in sobriety court. I support to waive any discretionary fines and costs, but this is the best plan of action.
Let's talk about that plan of action that Mr. Huff has recommended. He is recommending that you join our sobriety court program and that I defer any remaining jail time. You have 93 days maximum. He's recommending 93 days credit 8, leaving 85 days to deferred and put you on the sobriety court probation. As I said, I've been seeing a lot of you lately. You've been very polite, respectful, thoughtful, which is how you'd always been. And you said it when you talked to Pivotal. When you drink, you get in trouble. Every one of those things on your record has to do with alcohol. Without alcohol, you're this polite, respectful guy. You bought a brand new shirt. You're here today taking things seriously. Ms. Canfield, before we hear from Mr. Harvey, is anything you'd like to add here?
Hey, Your Honor, I have read and reviewed the pre-sentence and substance abuse assessment and reported recommendations. I agree that they're appropriate in this circumstance. I'm very concerned for the safety of Mr. Harvey as well as the members of the public if the alcoholism would be continued without addressing it. So I do feel sobriety court is appropriate in this circumstance. My concern is that this also occurred not only driving to the court, but apparently while he was on a delayed sentencing for a domestic violence proceeding. So I'm very concerned about that. Not only the inability to comply with the law and drinking and driving, but the inability to follow this court's orders under that particular matter.
Well, he ended up doing a considerable amount of jail time in that domestic case as a result of this. But he owned it, I guess. I'll give him that, and took his lumps. I certainly understand and share your concerns. Mr. Harvey, what do you think about coming into sobriety court?
I'm ready for it. That's what I need. I need something different. I need change.
How old are you, 31?
Yes, Your Honor.
You got an 8-year-old son?
Yes.
There's reason enough. 31's a little young, but obviously you nod your head when I said every time you got in trouble, it had to do with alcohol. One concern is you've been underemployed. You seem like a bright guy. You're polite, respectful. Up until now, you did have a driver's license. We may be able to get you a driver's license. The Pivotal report said you did have a report. Are you still working? Well, what are you doing right now?
Yes, I'm going to be back working for Austin Henschel.
Okay. And he's been very busy. Did you do my house?
I was actually on a fishing tournament that day.
All right. Well, he did a good job on my house. I didn't know whether you were there or not. But he's a good kid. We've known him since he was in high school. My wife had him as a student. All right. So when you say you're going to be back with Austin Henschel, tell me about that.
I just can't drive company trucks as of right now.
Well, why not a job with regular hours and a paycheck and insurance and that sort of thing, like applying at American Axle or International Paper or some of the companies that are hiring in Three Rivers?
I'm more of an outside seasonal kind of guy. I dig being outside. It's factories.
Well, it is. I've worked in my share of factories, and I wouldn't want to do that forever, but you've got some concerns about money and insurance for you and your son. But you've got some flexibility that allows you to do things. Now, our next sobriety court session is tomorrow.
Okay,
And we've got a good group of people in there right now. We just had a couple graduates. We have a couple that aren't too far away from graduating. There's a mixture of young and older people. The older people tend to be wiser. Men and women all kind of pulling for each other. But I put you in jail a couple times. I gnawed on your ankle a few times. And I guess we're gonna try this. The other alternative is just give you a big bunch of jail time. Ms. Canfield spoke to the need for protection of the public. That only protects them for a while. This program looks toward the long term of helping people get sober and better very often. In fact, almost every time people in sobriety court get a better job, they get promoted, somebody else hires them at a higher wage, they have more options, they get their driver's license back, so they have more flexibility. We've got a couple guys in the program right now who like their jobs, and the sobriety court was the difference between keeping their job and losing it. But as we say, we can only do what we can do. Put you on probation for 24 months. Sentence you to 93 days, credit 8, giving 85 days to do. Of the 93 days, 85 are deferred. So you've done all the jail you're going to do for this, if you can hold up your end of the deal. You talked about in your pivotal interview about how hard it is to do some of the things. There's lots to do. A lot of it we do online. You can come to you'll be here live tomorrow, but you can come either live or Zoom in to the meetings, which is something we didn't even consider when we started doing this. Everything was live. The treatment group is online. I pay for it. I pay for much of your testing because it's expensive. And the tests are an important component of it. In fact, can't have a sobriety court without it. And at some point, after 45 days, I don't know the status of your driving record, we may be able to get you a driver's license so you can drive to and from and in the course of work. The problem is you won't be able to drive a work truck because it won't have an interlock in it. And let's see. I'm going to grant Luke's request and waive your fine. It's usually $300 or $500.
Thank you, Judge.
Because there's a lot to pay for here. There's a $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee, and $960 probation oversight fee. The probation is 24 months. Almost universally, people complete it in much less than that. About the fastest you can do sobriety court, if you do everything meticulously, is about 13 months. The average is 13 to 15 months that the people graduate. Was there a police reimbursement in here, Matt? I didn't know.
I didn't see one requested.
I've not seen one either.
All right, well, you caught a break there. Yeah, there wasn't because it was a weird,
They picked him up at the courthouse.
way it was
Yeah.
done.
Mhm.
All right, let's add that up. 125 plus 100 plus 150 plus 960, which will be reduced. That's $1,335. I have a PR bond So I don't have any money to apply. He'll be in sobriety court. I look at the jail roster every morning and see who got arrested. Some of it, just I want to know what's going on. I want to know what the jail population is. I know many, if not most of the people in the jail. And I look for people that might be appropriate for sobriety court. You were appropriate for sobriety court in the domestic violence case, but you're not eligible for a sobriety court in a domestic violence. In fact, domestic violence can even prohibit you from being in sobriety court, but you needed an intensive comprehensive probation. So you've been going to AA. Which ones have you been doing?
The Carver Center.
All right, that's a good one. How do you get there?
I live right there at Riverside.
Oh, you're at Riverside now?
Yeah.
Oh, I guess maybe I knew that. Yeah, you can just walk down there. Carver Center is like the banker group in Three Rivers. There's a lot of good people in there. A lot of our people are in there. How many sessions have you been to so far?
I've missed 2 or 3.
But how many have you been to?
Ever since,
So like 20 maybe?
ever since the last court date, I've been going.
All right, well, that's a good start. I'm hopeful here because you are always polite, thoughtful, and you're sick and tired of being sick and tired. You're only 31. You're going to get healthier. You're going to think more clearly. You mentioned that your girlfriend had some concerns about your thinking. We're going to get your brain detoxed of alcohol, and then you'll be thinking clearly. Testing is directed, no drugs and no alcohol, including marijuana. I don't get the impression marijuana was a big issue, but we try to get everybody with a clean, sober mindset. All right. Autumn is here today, but she's going to be gone. That'll be helping us with the session tomorrow. We just met a week ago, so it'll probably be a bit abbreviated, but can you be here at the court tomorrow at 2:30?
Yes.
All right, I'll see you again tomorrow. You go with Matt. And I hope we can make this work. All right, Luke, thanks. All right, we'll stop the record. Talk to Mr. Ryan Frederick for a minute.
Shows the division locking up itself is.
Right.
If it's, or at least that's the way the research methods were to show that the recidivism rates.
Thanks,
drop.
Judge.
Thank you, Luke. I'm hopeful with him.
Short term.
Yeah.
Uh,
I had him on
lack of
that
recidivism,
page.
but then as soon as you get off the scram unit.
It's one of those, it's
Whereas
blackout
the long-term
drunk.
success
I
rates
don't know
are
why I'm in
they're
jail.
locking up land.
Yeah, he woke up in a chair and then, yeah,
Right.
so.
Okay.
Yeah, so
It's really
I
sad.
mean,
That's
sometimes
sort
it
of
feels
like,
better
oh,
to
what did I
like know
do?
for sure,
Thing.
especially for
So,
the society, but at the same
long
time,
time
it's
coming.
like.
Angelique,
Data
you've been
says,
here about a month. Are you going to the prosecutors conference at the Grand Hotel?
Oh, I don't think.
They haven't told you yet.
I've not been forewarned. No,
Oh.
no, that would be a pleasant.
Did
thing
you ever
attend,
get to
but
go in any of your iterations?
No, because the 15-year award was after I left Calhoun, so I
Mm.
didn't attend that one either.
Hmm.
Yeah. So
I
not
got
yet.
a 20-year award.
I'll get there
You'll
soon.
get there soon enough. All right.
You can send a proxy.
Oh, sure.
All right, let's talk about that. Judge Middleton had himself quite a layered afternoon here, juggling zoning disputes, missed court appearances, and then rolling right into a sentencing that looked a lot more like a candid life check-in than a dry legal proceeding. On the zoning side, we had Alfred and Joanne Yoder, noticeably absent, which is a theme in their file. The court went through a history that included permanent injunctions, show cause hearings, missed show cause hearings, bench warrants, and eventually cash bonds that the Yoders themselves posted at the jail. For a brief moment, it looked like things might stabilize. But when the appointed hour rolled around today, neither Yoder appeared in court. And that's not a small oversight. When you've posted bond to guarantee your appearance, skipping the hearing is like pulling the pin on a hand grenade and just waiting for the bang. Judge Middleton, who had clearly spent hours combing through these files, was visibly disappointed. He wasn't angry in the wild, yelling sense. He was firm in the, "this is serious business, and I expect you here" way. He carefully laid out why he had jurisdiction, declined to disqualify himself, and then explained why fresh bench warrants were not just appropriate, but necessary. The order gave the Yoders a brief window, until the following Wednesday, to turn themselves in before sitting in custody with no bond. The commentary was frank. The court wanted a conversation, maybe even a path forward, but you can't talk to empty chairs. On the township side, Attorney Thornton came prepared and calm, laying out the defaults, the injunction standards, and the rules of civil procedure in a way that kept the proceeding grounded. His paperwork was tight, his citations were clean, and he pressed the point that zoning law isn't something you get to opt out of just because you disagree with it. Middleton agreed, signing off on a preliminary injunction by default. And in doing so, he reminded us all that zoning cases may not be flashy, but they matter, because behind the dry terms are buildings, safety concerns, and neighbors who live with the consequences. The judge also took a moment to stress what should have been obvious. The Yoders need a lawyer. Not to curry favor, not to play the system, but simply to keep themselves out of a spiral of contempt hearings and warrants. It was a textbook Middleton moment, equal parts judicial order and practical life advice. Then the hearing pivoted sharply into a different kind of case, with James Jonathan Harvey appearing for sentencing. And the contrast was stark. Unlike the Yoders, Harvey was in the room, suited up in a new shirt, flanked by counsel, and taking things seriously. Judge Middleton walked through the report, acknowledged the prosecutor's concerns, and cut to the heart of the matter. Every single scrape Harvey had with the law tied back to alcohol. The solution wasn't more jail, but structure, accountability, and sobriety court. What stood out here wasn't a grand lecture, but a judge genuinely connecting with a young man who, without alcohol, comes across as polite and steady. The conversation about work and life plans felt less like punishment and more like a nudge toward stability. Even the prosecutor, while rightly cautious, supported the idea that sobriety court could be the right path. It was an example of the system at its best, firm but not punitive for the sake of it, focused on rehabilitation when there's still time for it to matter. So we had it all in one sitting. Absent parties ducking a serious zoning fight, a township lawyer methodically advancing his case, and then a defendant standing ready to grab the lifeline of sobriety court. Through it all, Judge Middleton kept the courtroom steady, patient, thorough, with a touch of dry humor about vacations, deer season, and even a YouTube shout-out to a visitor from Oklahoma. It wasn't sensational, but it was real, and it showed exactly how local courts work through messy, everyday problems in public view. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I rate everyone.